We need to mute. All right. Good afternoon, everyone. Welcome to 8D. While you're in court, if you don't want to wear your mask, that's okay by me. If you want to wear your mask, that's okay by me. When you leave the courtroom, it's important that you put your mask back on because then you're in the public space of the courthouse. We have a plea and arraignment calendar and a few non-plea and arraignment matters to work through, a bond hearing, a plea, and there may be a couple other things, but we're going to start with the plea and arraignment, see who's here. Hello. Pardon me? They should. You need it. I don't know where everyone is, but we're going to get started. All right. Position 1 has been dismissed. Is Roland James here?
Yes, sir.
Hey, Mr. James, I'm Judge McBurney. Nice to meet you. You have a case from 2012. That case has been dismissed. I signed that order this morning. Unfortunately for you, you have a new case as well. That's unindicted. It may come here. It may go somewhere else. There are 15 of us who handle criminal matters. You were here today to deal with the case from 2012, and the state, in reviewing that case file, has decided not to proceed with it. That does not mean that your new case, the unindicted one, has gone anywhere. And let me let you know what the next event is in that, just so you're not surprised. 206 577. Here it is. It doesn't say anything. So there's nothing coming up yet. It's unindicted. You've got a bond. Keep complying with that bond. If you move, let the bonding company or wherever you got the bond know your new address so you don't get a bench warrant, okay?
Yes, sir.
You're welcome to stay the rest of the day. You're also free to go.
Thank you. Have a good day.
You too. Thank you, Ms. Charles, for your work on that case. Positions 2 and 3 are John Fant, F-A-N-T.
Your Honor, Ms. Woods put a waiver in on the.
Okay.
She got a hold of him.
She tracked him down and she's entered a waiver of arraignment.
Right.
Great. So we'll get a scheduling order out for him. And those two cases will move along. Don't know about position 3. Maybe they can work out. Position 4, Andre Williams. So the next few positions, 4 through 6, are all new indictments, really old matters. Whatever Mr. Williams allegedly did, he allegedly did in April of 2018. That's going to be true for the next 2 defendants after that. So Mr. Williams is not here. The fact that Mr. Williams might have moved in the course of 4 years while his case was not charged surprised me a ton. Anyone have any information about Mr. Williams?
We did not have a good cell phone.
Okay, Ms. Charles?
Your Honor.
I don't know if this would be your case. It'd be Mr. White now.
Today and
All right, let me look this one up. If there's been some kind of activity in the case more recently than 4 years ago. Nope. In fact, it was closed by pretrial in September of 2018. So it may be through the victim, since it's an aggravated stalking. Let's see. There's a alleged victim. That person might be able to help the state get a better address for Mr. Williams, but I'll talk with Ms. Nelson. I don't want this just to be an open case because you can't move it if we don't have a Mr. Williams. I don't know about the bench warrant. I'll put bench warrant question mark. He's clearly not here. All right, position 5 is Mr. Perez Vasquez.
Good afternoon, Your Honor. Kendra Robinson standing in for Jerome Lee on behalf of Ms. Perez, Judge. Would say the state.
Well, where's Mr. Perez? I know you're here, which is good. Is he right there? Oh, it's Ms. Perez.
She goes by she. Yes, that is Ms. Perez. That's correct, Judge.
Thank you, Ms. Perez. Nice to meet you, Ms. Perez. You're with your lawyer where you ought to be. And is this going to be your case, Ms. Patel? Whose case is this?
Yeah, it is, but my information is that it's a Mr. Perez.
Well, things change. So it's Ms. Perez. That's what Ms. Perez's lawyer has said. So
Thank you.
Ms. Perez is in there with her lawyer. We have an interpreter here. Ms. Robinson, do you need an interpreter for?
Not to communicate. Yes, Miss Perez needs an interpreter. She speaks English, but I just think it's best for the interpreter to translate. So she's been able to understand you thus far, Judge.
Yep.
But yes.
Well, but before we invoke the services of the interpreter who's here, it's a plea and arraignment. And so if you know, Ms. Robinson, that Ms. Perez is waiving arraignment because of a conversation you or Mr. Lee have had with Ms. Perez, you just need to tell me that. We'll get you the form that you need to complete that will constitute the waiver of arraignment. Mr. Lee's already filed an entry of appearance. His name is on the calendar here, and then we can get a scheduling order in place.
That is absolutely the case, Your Honor. So she's going to waive formal arraignment, Judge.
Okay. We will get a waiver of arraignment form to you / Mr. Lee. If you all would please complete it and e-file it. Once you do that, that'll trigger a scheduling order. Discovery will keep flowing if it hasn't flowed completely yet. And then we'll see folks for a motions hearing or a status conference, whatever comes up next. Ms. Patel, do you have anything more in Ms. Perez's case?
I do not. Some discovery was served on May 10th, and I will make sure the rest of it is sent over.
Great. And Ms. Robinson, Mr. Lee remains lead counsel. You're covering for him today. Is that a fair statement?
That is true, Your Honor. Mr. Lee is lead counsel, but I will appear pretty much every time on the case, Judge.
Great. We're happy to have you. I just wanted, so Ms. Patel knows who she should be sending discovery to, who she might be calling to say, let's discuss this case from 2018. Would she be trying to track down Mr. Lee or you or either one of you?
Well, the way it works is she would track down Mr. Lee and she would communicate all those things with Mr. Lee, and then he directly would give those things to me. But he likes for them to flow directly to him first. Okay.
Well, that's what they'll do. Ms. Robinson, anything else on behalf of Ms. Perez?
Nothing further today, Your Honor.
Okay. Ms. Patel, anything else?
No, Your Honor.
All right. So can I excuse the interpreter?
Yes, ma'am. For the defense, you can.
Great. All right. Thank you for being here.
Thank you, Your Honor.
We'll
Thank you, Your Honor. See you all soon. Bye.
All right. So I was just checking out the Ms. Perez situation. They'll file a waiver of arraignment and then we'll be off and running. Did you need anything else?
No.
Okay. Great. James Barron.
He's on the call, Your Honor. He, at first appearance in 2018, he didn't qualify. I don't know where we are with that.
Okay. Mr. Barron, can you,
Yes, Your Honor, I'm here.
there you are. I'm going to spotlight you. Whoops, I just spotlighted the wrong person. It's Mr. Carr. Let me make it Mr. Barron. Things shift around. Replace spotlight. There he is. All right, there's Mr. Barron. Mr. Barron, you were, excuse me, arrested 4 years ago. You've now been indicted. I don't know if the statute of limitations was 4 years. They made it by like 11 days. But we need to sort out, Ms. Primovic, you're saying whether Mr. Barron still qualifies?
He did not qualify at first appearance.
Oh, he did not qualify at first appearance. Thank you. I missed the not. So, Mr. Barron, if you are unable to afford a lawyer, you will have one appointed to represent you, but your ability to afford a lawyer is not, gosh, I don't feel rich, but there are actually certain financial thresholds. If you're gainfully employed, you got a bank account, you got your own car, you probably are not eligible to have the public defender represent you, but I don't make that decision. The public defender operates that screen. I think it would make sense for you to speak with, I don't know who's sitting next to you today.
Your Honor, this is our new attorney, Leanne Feely.
Ms. Feely exists. Welcome.
Thank you so much.
It's nice to see you. Have you been fully oriented so you get cases now?
I believe so.
You believe so? Excellent.
Walked right in on it, Judge. We had them all waiting for with a bow on them.
But I'm starting to doubt that I really have two public defenders because you're here and now Ms. Wood isn't. It's like Ms. Primvik's always like, nah, trust me, there's two. But could one of you speak with Mr. Barron if I send him in the chat phone number, or you could send him in the chat a phone number to see if he qualifies, just so we don't do it in this public setting?
Right, I can do that, Your Honor. I can help out.
Okay. Mr. Barron, why don't you, do you know how to do the chat feature in Zoom?
Yes, sir.
Why don't you send me your phone number? I'll write it down and I'll give it to Ms. Primovic, and she or Ms. Feely, one of the two public defenders, will give you a call in just a second. And we can figure out whether, unless you know, I don't mean to prolong this. If you have $1 million in the bank, you don't get an appointed lawyer. You got to hire one, and you may have already hired a lawyer. What's your plan?
I think that I'm probably right on the verge of qualifying for a public defender, and I do not have the money to afford an attorney myself because I was quoted $10,000, and that's way beyond my means.
Okay.
But so yes, I'm just trying to qualify for a public defender, and if not, then I have no idea.
You fall into that awkward category. Okay. What I need you to do is send me your phone number through the chat. I'll write it down. I'll give it to Ms. Primovic, and she or Ms. Feely will call you in just a couple minutes and have that conversation. Then if the answer is yes, they are going to represent you, we'll have the conversation I was hoping we could have today since you showed up. And that's what are next steps in your case. Okay.
Alrighty. Thank you, Your Honor.
Yep. All right. Well, I'll wait on that and we'll move to the next position. Farard Fallen.
Your Honor, Ms. Wood's got in contact with his mother, who verified he's in the hospital.
Okay. Reset. Do we have, so Ms. Wood maybe got good, more current contact information?
She has really good contact.
Okay. How far out should we bump this? A couple weeks?
A couple weeks should work, Your Honor.
All right. Ms. Charles, you all right with that? All right. We'll reset it 2 weeks-ish out.
Yeah.
Oh,
It's
Mr.
been there 1 week, so hopefully
Yikes.
there for a long time.
Okay. All right. But it sounds like family is in a position to keep Ms. Wood informed.
Correct.
I guess if it gets extended, we'll probably want some medical documentation of what's going on, and we'll go from there. Thank you. Position 8, Zolly Ford.
Ms. Woods got in contact with Mr. Ford, and she filed a waiver of arraignment.
Okay. She's making her absence relatively painless. That's a waiver. We'll get a scheduling order. Aaliyah Howard.
The attorney filed a waiver of arraignment.
Brian Howard is the attorney.
Yes.
I'm feeling like people don't want to come on down here. All right. Waiver. Cody Polio or Polio.
It's Polio, Your Honor. Good afternoon, Attorney Bando. He's on the Zoom call as well.
Okay. that all happened real quickly. Up, Attorney Bando. All right, I see you. And then is iPhone, is that Mr. Polio?
Yes, sir.
All right, how you doing, sir?
I'm doing well.
Good. And let me. Oops, I muted the wrong one. Can you unmute again, please, Mr. Polio? We had two things that just said iPhone and one of them was making noise. All
Yes,
right,
sir.
I'm just trying to get your case up here. Oh, we got 3 defendants on your case. All right. Here it is. Yep, Ms. Bando, you filed an entry. That is great. What's the situation? Are you waiving arraignment today on behalf of your client?
Yes, Your Honor, we'll waive formal arraignment, enter plea of not guilty.
All right, we'll get a scheduling order issued. That'll give the state a deadline for providing discovery to you. It'll set a date for motions to be filed and when we might hear them if they require a hearing, and we will go from there. Ms. Charles, this is going to be your case?
Yes, sir.
Okay. Any concerns about discovery? Great. And your microphone is on?
Yes, so.
Okay.
As I said, we just sent, initial discovery has been sent, and as I continue my review, I will follow up any supplementals.
Okay. Ms. Bando, do you have anything you want to discuss in connection with the case at this time, or you'll just wait to get the rest of discovery?
Yeah, I'll just wait to get the rest of it, because I noted that it was a body cam, so we'll wait to make arrangements to get that.
Okay. The way a lot of that has been transmitted of late is you get a link to an evidence.com website and download it that way. But you and Ms. Charles can coordinate. It may be that this is one where it's a thumb drive. I think the district attorney's office is trying to move away from buying 1 million thumb drives and distributing them and having the evidence available in the cloud, if you will, and you pull it down that way. Mr. Polio, I'm just looking at your bond. Want to remind you that the special conditions of your bond are that you stay away from a bunch of people with the last name of Welch and that you stay away from an address on Mason Turner Road. Understand that?
Yes, sir.
Is that an issue for you or that's not a problem?
That's not a problem, Your Honor.
Excellent. Well, you keep doing that. You should be all squared away. Ms. Bando, if there's nothing else on behalf of your client, you two are free to go.
All right, thank you, Judge.
Yep. Co-defendant is Catherine Sanders. Ms. Sanders is here in court. Your lawyer is Tracy Reeves.
Yes, but no longer.
No longer.
He stated that when he had COVID and then he no longer wanted to represent his own media counsel.
Oh, okay. I received the medical news and so I knew that's why Mr. Reeves was here. I didn't know you two had parted ways.
Well, I paid him, but I just haven't been able to get in contact with him again. I received an automatic message that they will be out of office due to COVID.
So are you getting your money back?
Hopefully.
Yeah.
Because it was a lot of money and I would like to use that for counsel, because
Right. The way it's not supposed to work is you pay a lot of money and then the lawyer says, I'm not working for you anymore.
he sent that, he sent me the letter on Monday and I received correspondence on Friday that I had to put it.
Okay.
Did not have enough time.
Okay. Well, we'll certainly give you time to retain new counsel if you need to, but we're going to need to have a discussion with Mr. Reeves. He actually can't drop off the case unless I give him the green light to do that. The red light, or at least the yellow light, give Ms. Sanders her money back, and then the green light. And we'll see. He may have a great explanation and there may have been a miscommunication. He wants to keep your case, but he needs to keep his distance right now. Let me look at your bond. So unsurprisingly, your bond conditions are the same as Mr. Polio's. You need to stay away from the Welch's and that address on Mason Turner. You should keep doing that. The address we have for you, I'm not going to say it out loud.
It's correct.
Oh, you are, because you're getting stuff in the mail? Okay, something on Bolton Road? Okay, great. Then you'll keep getting that. Mr. Reeves remains your attorney of record. And until I allow him to withdraw, he remains your attorney of record. So we're going to reset this for not very long. I don't want Mr. Reeves to be unwell, but the recovery is quicker now and the periods of quarantine are shorter. So we'll need him to come to court to either put up, I am her lawyer, or refund and be on his merry way. You'll need to be back for that. It can be virtual, meaning you could Zoom in because we've met now, but you may want to be here in person. It will be easier if Mr. Reeves starts saying some things that you want to respond to if you're here as well, but we'll get you notice to be back here, okay? All right. You're welcome to stick around, but there's nothing more we can do without Mr. Reeves. Yep. Let me get you that phone number. Thank you, Sarge. Ms. Primovic. All right, and the third co-defendant is Mr. Stewart, and I think he's on this call. He is.
We have him, Your Honor.
All right, and we would be Ms. Feely or Ms. Wood?
It'll be Ms. Feely.
Okay. Is she not yet authorized to talk?
Your Honor, you know, she hasn't gone through all of
The talking training? All right, well, you keep it up.
Have they use sign language? Crazy.
All right, Mr. Stewart, if you are on, if you could turn your camera on and unmute.
Yes, I'm here, Your Honor.
There he is. All right, let me put you on the spotlight. There he is. Okay, Ms. Primovic, there's Mr. Stewart. Tell me, are we waiving a rate? Oh, he just has one count in this indictment. Got a little piece.
Maybe I'm pleading not guilty.
Okay, so Mr. Stewart, Ms. Primovic, who you may be able to see on the camera, there, she just leaned in. She is a supervisor in the public defender's office. Seated with her is the lawyer who is not a new lawyer, but she is new to the Fulton Public Defender's Office. She will be taking your case. She'll be reaching out to you soon. We'll make sure we've got good contact information in just a moment. And what's going to happen next is the prosecutor will make sure she's provided all the discovery in your case. And then you and Ms. Feely will talk about, well, what are we going to do with this case? Is this one we want to take to trial? Are there motions we need to argue? Or is this something we should try to work out? And you and Ms. Feely will make those decisions. And then I will see you when it's time to handle one or more of those things. Does that make sense?
Yes, it does, Judge.
All right. Any questions about that?
No, sir.
All right. How do you say your first name?
Colliers.
Collius. Got it. So the contact information we have for you is an address on Jet Street. Is that still a good address for you?
Yes, sir.
Do you all have a good phone number for Mr. Stewart? And email. Excellent. So the PD's office knows how to reach you. You'll know how to reach them soon. I'm going to get out of the way and just let you guys do what you need to do. Ms. Charles, do you have anything else for Mr. Stewart's case?
No, Your Honor. Just as soon as Ms. Feely does entry of appearance, I'll get discovery started to her.
Great. So Ms. Feely, I'll be one of her first projects would be entry of appearance. Be a good test. All right. Is Mr. Stewart free to go? It's fine by me. All right, Mr. Stewart, you've done what you needed to do. Thanks for dialing in. You will get something to that address on Jet when you next need to come to court. But well before then, you'll be hearing from Ms. Feely, okay?
Yes, sir.
All right, you have a good weekend.
You too, sir.
That is it for the plea and arraignment calendar. The three other things I know we're working through. We're gonna have a bond hearing on Mr. Russell. Ms. Clark's here for that. And Mr. Abate. We're gonna take the Roberson plea, hopefully. And what we'll do right now is the car update. Is there anyone here for something that is not Roberson or Russell or Carr? Yes, ma'am.
Yes, my name is Ernest.
Oh, yes, you're not on the calendar. We will talk. I got Ms. Charles reminded me of the situation. I remember your case. Yep. All right, I think that's it. Why don't we quickly do the update on Mr. Carr's case? Mr. Carr's on our trial calendar, and he's been charged with some fairly serious offenses. The alleged victim in his case, last name Owens, has pled guilty to one or more federal crimes in Florida and is set to be sentenced by a district court judge in some district in Florida. I think later this month, Ms. Charles, is it in July?
However, they yesterday confirmed that we have now permission to speak with him on Monday, the 16th at 8 a.m.
Oh, okay.
So we're making some progress in
all right.
contact with the victim.
So you and an investigator will be able to speak with Mr. Owens on Monday.
Yes, Your Honor.
All right. What about permission for us to borrow Mr. Owens so that he could be here if he needed to be here?
Ms. Vaughn is working on that for me as well.
Okay. It sounds like you've opened up some good channels of communication, though.
Yes, we
All right. So, Mr. Cruz, tell me what you have any other questions about where we are? We really can't try this without Mr. Owens. You really can't work it out in a meaningful way until the state has had a chance to talk to Mr. Owens. You've helped me understand that there are some potentially persuasive defenses that Mr. Carr has, but it sounds like until the state can talk to Mr. Owens, you're not going to get a lot of traction with that. Your client's on bond, so it's not a situation where we need to be talking about the equities of, well, why isn't the state ready to go? Other than that, certainly Mr. Carr is entitled to have a trial, which we'll do as soon as we know about Mr. Owens's availability. Anything you want to add or questions for the state?
The only question I have, and Ms. Charles has been very responsive, extremely responsive and extremely professional. The only question I have, though, and I don't know if it's for Ms. Charles or the court, how would we speak to Mr. Owens? Because that's what, since the beginning of this incident, we've attempted multiple ways to speak with him, but since he's been in federal custody, it's been no way for us to reach out to even figure out how to speak with him.
So I've got a couple thoughts about that. One, I'll ask Ms. Charles to ask Mr. Owens if he's even interested in doing that. And so she could relay to you, he is interested, and then we'll get to part two. If she relays to you that he's not interested, then you might as well just wait till we get Mr. Owens up into Fulton County before you expend the resources to try to connect with him. If he is interested, then Ms. Charles may be willing to share with you the hoops she jumped through to get access to Mr. Owens. He, of course, has a federal defender. I assume it's appointed counsel. He's got a defense attorney. So while Mr. Carr's case may have nothing to do with Mr. Owens's case in Florida, you may need to run any contact inquiries through Mr. Owens's lawyer. So my thought would be, let's have Ms. Charles have that conversation with Mr. Owens. She may come out of that saying, you know what, we're offering a diversionary sentence to Mr. Carr. Who knows? She may come back saying, we're going to upgrade the indictment and add a bunch more counts. But depending on how that goes, she should have more info for you, Mr. Cruz, as to whether it makes sense to try to talk to Mr. Owens, and if so, how to do that.
Yes, sir.
Otherwise, Mr. Carr remains on bond. I don't remember where this case was on the upcoming trial calendar cycles, but until I get a sense that we could pry Mr. Owens out of Florida. I do not expect either side to announce ready. For Mr. Carr's sake, I will let you know there will come a point where I say we need to go forward with this case. And if the state can't produce Mr. Owens, ultimately that's a state problem and not a defense problem, unless the defense says, no, we don't want to go forward without Mr. Owens. Why you'd say that when he's the victim, I don't know, but things could happen. And if you were to say that, then I'd continue it. But ultimately, if the state can't procure Mr. Owens, that's a state problem, and they might have to not go forward then, and Mr. Carr would go his own way. We're not quite there yet, but this case is not getting younger, and they seem to be moving not so fast down in Florida.
And Your Honor, I understand that the standing order against the speedy trial was lifted on, was it May 1st, or was it reissued?
So one, no one is against speedy trials, but there was an executive order entered by the chief judge consistent with statutory authority that sunsets and authority from the Supreme Court of Georgia that has extended the suspension of the speedy trials, the statutory speedy trial. So you do have, you timely filed one in Mr. Carr's case. But you filed it when there was a hiatus on speedy trial demands, and that hiatus remains in place at least through the end of this calendar year. That extension that Chief Judge Brasher signed extends that through the end of the calendar year. So right now, that clock is not ticking, and it has not begun to tick. So that's the answer is yes, the hiatus has been extended through the end of 2022. We need to have resolved this case before then anyway, independent of your speedy trial demand. But I'm expecting an update from Ms. Charles after she has a chance to talk with Mr. Owens.
Yes, sir. Thank you.
All right. Anything else?
Not from the defense, Your Honor.
All right. Mr. Carr, you doing okay?
Yes, sir.
Good. All right. Continue to comply with your bond. Ms. Charles, let us all know, scale of 1 to 10, how happy you were with the conversation with Mr. Owens after it happens, okay?
Yes, Your Honor.
All right, thanks.
Thank you, Ms. Charles. Thank you to the Honorable Court. May we be excused?
Yep, go enjoy Friday the 13th.
Thank you, Your Honor. In the office, of course.
Okay, where you need to be. All right, Mr. Barron, did you, Ms. Primovic, have a chance to speak with Mr. Barron?
I did, Your Honor. He qualifies.
He qualifies. Will this be a Ms. Wood or a Ms. Feely
This
case?
would be a Ms. Wood,
Okay. Did you speak with Mr. Barron about waiving arraignment?
and he's waiving arraignment, pleading not.
Great. All right. So he's waived away arraignment. We'll get a scheduling order. Mr. Barron, did you get something in the mail telling you to be here? How'd you know to be here today? 4 years after your case, you were arrested.
I actually received 2 notices in the mail, one on last Tuesday and one last Friday.
So we've got the right address for you.
Correct.
Fantastic. Then you'll keep getting stuff in the mail, but you'll get in a much more timely way contact from Ms. Wood, who is the public defender who'll be representing you. Okay.
Okay, thank you, Your Honor.
You're welcome. This is an infrequently charged count. Is this a Ms. Charles case or a Whitenauer case or a Patel case?
Yes, Mr. Adia Whitenhour.
Okay.
Which I'm just covering for him today.
Got it. I'm just curious who will be shepherding it through on the state side.
It'll be Whitenhour, Adia.
All right, great. Thanks, everyone. Mr. Barron, you're free to go.
Thank you, Your Honor.
All right, I have a Zoom call. I have to be on it too, I think. I'm not seeing it here, but I think, do you think we can do the bond hearing, Ms. Clark? I don't want to rush anything, but if you said, look, it's an hour presentation, I want that to happen, but we would do it after that call.
No, it won't take long.
We'll do it in just a second then. And then we'll take the plea after I take my call, if that's okay. And I think that's all that's left. I think we've covered the PD stuff unless you guys have some exciting announcements.
Can I just inquire as to the arraignment, because can I do it today? I'll be out of the country on the 31st.
Oh, right. He's on for plea and arraignment as well. This is reconsideration of bond and arraignment.
Okay, So
We'll do both.
Right.
Yes, ma'am,
Thank
both.
you.
Yeah, I thought it was on just for bond, but it says in big letters, plea and arraignment. I was ready for bond. So we'll definitely do the arraignment. Are you ready, Mr. Abate?
Yes, sir.
Is Mr. Russell here?
Yes.
Great, let's bring him out.
May I be excused? I
Yes, ma'am.
think I'm done. Jinx, have a great weekend.
You too.
Judge, just so I can inform whoever I need to inform, do you think you'll be done with your call before 3 o'clock?
Oh, yes, I've told these people that I'm covering something for Chief Judge Brasher, and I've told them that they can only have about 20 minutes.
Thank you.
Yep.
Hello.
Hello, who's this?
Yes, I'm Mrs. Jenkins. I'm Marquise Jenkins, the victim. I'm Marquise Jenkins' grandmother, and I was asked to be here today. I just want you to know that I am present.
Fantastic. And when Mr. Abate goes, I'll be hearing from the state, and he's the prosecutor. I'll be asking him who is here on behalf of Mr. Jenkins. And I bet he was going to introduce you, and there may be other people on this call as well. And I will gladly hear from whomever I need to hear from, okay?
10-4.
10-4.
Hello.
Hello,
We're his godparents.
Mr.
also on
Jenkins'
the call.
godparents?
Yes, sir.
Okay, great. I'm going to mute you as well. When it's time, if there's something that Mr. Abate wants you all to add, I will certainly hear from you. And I appreciate you flagging that you're here.
All right.
I'm just going to mute things so that we don't get any feedback, okay? Thanks.
I appreciate.
Is this the case where there was a struggle over a bag and maybe the state's view is someone sort of started the process? Maybe that was Mr. Russell, but Mr. Russell wasn't the shooter, it was the other guy. And I did the bond hearing, so I'm trying to recreate in my mind, so you all don't have to recreate too much. You're free to cover whatever you want, but
You did.
okay. I know I did the bond. I learned that I caught both those cases. Friend shooting friend with the rifle and this one. It's not supposed to work that way. I hear the bond. I say, you'll probably never see me again until you see me again.
Hey, Judge, how you doing?
I'm well. How are you?
I'm fine. I'm Latron's mom. I'm online too.
Great. Thank you for being here.
Thank you.
Ms. Rivers, are you ready?
Yes, Judge, I'm ready. Good afternoon.
Good afternoon. Happy Friday. All right, let's go on the record. This is 22 SC 181907. We are here today with Mr. Russell. He is represented by Ms. Clark, and we're going to handle two things today. One, Mr. Russell is here for plea and arraignment. And then two, Ms. Clark has filed a motion to modify his bond, to reduce his bond. I set a bond for Mr. Russell in February. I think it was the day after Valentine's Day. And I set an $80,000 bond and told Mr. Russell, you'll probably never see me again because your case will get indicted and be randomly assigned to a different judge. It was randomly assigned to me. And so I'm seeing Mr. Russell and the same attorneys again. Ms. Singleton is here as well. Ms. Clark, are you waiving arraignment on behalf of Mr. Russell?
Yes, no, I need waiting arraignment if he's not guilty.
Great. So he's entering a plea of not guilty. The waiver of arraignment will be noted. We'll enter a scheduling order, and the state will continue to comply with its discovery obligations. The other thing we were going to do.
Excuse me, Your Honor, does the defendant sign the indictment in this courtroom?
Well, in normal times, yes, but we're not doing that just because of COVID. But we happen to be on the record for Mr. Russell, so there'll be a record made of the entry of the plea of not guilty through what you just told me. But we now are signing indictments when there's a plea or just before trial. And that's the way we record that. Mr. McKinnon is not on the calendar today. Is he fugitive? Did we already have his plea and arraignment?
I believe he is on another calendar.
Just sometime soon. I just don't want them to be way out of cycle.
They're not.
They're not. Okay,
We were
great.
originally scheduled for May 31st, when I would not be here. So
Got it.
I asked if we could just do ours together.
So we accommodated your schedule.
Yes, sir.
Excellent. Well, Ms. Clark, when you are ready to articulate why Mr. Russell's bond should be reduced, please do. And if you'd make sure, like I said, you're welcome to keep wearing your mask. I want to make sure the court reporter can hear you. So just be as close to one of the microphones, either podium. You're welcome to remain seated. That don't bother me. Just get near that microphone, please.
Yes, sir. Your Honor, as you stated, we did have a bond hearing on February 15th, and you did grant Mr. Russell an $80,000 10% bond. Unfortunately, his family has not been able to get the 10% bond amount of money. So I'm asking for a reduction in the bond, Your Honor. My client will turn 17 on Sunday, and Ms. Drew was nice enough to accommodate me before his 17th birthday because he is transferred from Metro to the Fulton County Jail with the adults at that time. And I was trying to get him out prior to the movement. Your Honor, Mr. Russell comes before the court. As you can recall, he is the one that is fighting with the alleged victim in this particular case, and he is not the one who pulls out a gun and shoots him. So he is not the gunman. He wasn't in possession of a firearm, and he does not have a juvenile record. If Your Honor is able to reduce the bond, the family is going to try continually to make the bond. If he turns 17 and is moved over to the county jail, he'll lose the wraparound services of DJJ and the free ankle monitor. So we'll ask that you, Ms. Singleton will still be the supervisor, pretrial officer that would supervise Mr. Russell while he's on the 24-hour curfew and the other conditions of the bond. And we would ask that you add the free ankle monitor from the county jail so that it would not be another burden on the family in case they're not able to get him out by Sunday. But basically, Your Honor, those were the facts. And because of his age, we're asking that you reconsider and lower the bond, lower it to 50 or 40,000 so that they could make a bond. Because at this point, it's like my client being under no bond, even though he is under a bond. I appreciate it.
Okay, thank you.
Your Honor.
Ms. Singleton, I've got a couple questions for you, if I may. You've taught me before the fact, if Mr. Russell were out, if he were on bond and under your supervision, the fact that he turned 17 would not cause all those supports to fall away. Do those stay with him till 18 or 21?
If he had been able to get out before he goes to the jail, he would have kept everything till the case is over.
Till the case is over. He could be 38 years old and you'd still be there with him. What'd you say, Mr. Russell?
Pretty much, Ron. I've had some 27, 28-year-olds.
Okay, that's not this case.
Yes, but he would have been able to keep everything until the case is resolved. Once he goes over to the jail, he will not be able to have the wrap services. He can't get the DJJ ankle monitor. I have spoken with his mother to determine, because if the court were to reduce the bond today to a number that they were able to make, he still physically has to leave Metro.
Yeah.
And they're picking him up on Monday.
Yeah.
So there are checks that the Metro has to do, background checks and screens, and that process usually takes 4 or 5 days. But I did go ahead and have them do them, just in case there was a number that if the court reduced it, that the mother would be able to make. So that he would be able to get the wraparound services, the in-home counseling, as well as the DJJ ankle monitor. Of course, if the court granted him the county-funded ankle monitor, that would satisfy that. But I was hopeful. The defendant does have a prior diagnosis prior to this case that I was hoping that he would be able to benefit from the wraparound services.
So it sounds like the main thing that would be lost if, despite our best efforts, bond isn't posted till Tuesday, would be the wraparound, because there's always the county funded ankle monitor done, check. That's how I would do it anyway, unless it was Latron O'Neill, as in son of Shaquille O'Neal. They'd be able to afford it, but we'll take care of the ankle monitor. It's the wraparounds that would be gone.
Yes.
Would you still be, if it was subject to pretrial supervision, would you still be the person who is providing the supervision, or it would be through adult PTS?
It would still be me, Your Honor. I keep them from the time they come in as SB 440s till it's over.
Got it. Hence the 27-year-old or 28-year-old.
Yes,
Okay.
Your Honor.
All right. So we don't lose you. We wouldn't lose ankle monitor, but it would be all the supports that come with the services that accompany you.
That's correct, Your Honor.
Okay. All right. Ms. Clark was there. I know Ms. Brooks, she's raised her hand. I don't know if are you okay if I hear from Ms. Brooks?
Yes.
Okay. Yes, Ms. Brooks.
Thank you, Your Honor, and thank you, Ms. Clark. But like I said, I'm a mom. Now, I don't just have Latron, Your Honor. I have 10 kids and a grand. I have a trucking company, but trying to take care of all 10 kids, get Latron home and the grandbaby, that's kind of hard to do and keep everything running. So I'm asking for today at least a 20 to 30, or, just so I could get them home and we can go from there. Like I said, I'm guaranteed he's coming to court, everything, the services that they're offering. I just need a chance to get them home.
Okay. I appreciate that. And I appreciate everything you're doing to keep your family afloat. You're working very hard, and it's very impressive that you've done what you've done. Thank you.
Well, we got to stay strong as kids nowadays. So, hey, I'm here.
All right. Thank you. Mr. Abate.
Thank you, Judge. I would respectfully request that you deny defense counsel's motion for reconsideration of bond. I think the bond that Your Honor set back on February 15th of 2022 was more than reasonable, given the charges in which Mr. Russell is charged with. I would bring to the court's attention, I know the court remembers the facts based on the recitation that you recited earlier, but I would remind the court that Mr. Russell started the fight with Mr. Jenkins, the victim, who is not able to go home to his family because of the initiation of this entire incident by Mr. Russell, which led to the victim's ultimate death. So based upon that, I would respectfully request you deny defense counsel's motion, as there's been no change in circumstances since your previous setting of bond at $80,000. The victim's grandmother is on the call, as well as his godparents. You did hear from his grandmother last time, and her position remains the same. I understand that he received a bond last time, but she is under the opinion that he doesn't deserve a bond, and doesn't believe that he deserves a reduction in bond, as she believes the $80,000 is more than reasonable.
Okay. Thank you. No, and I understand her perspective, and she made it clear last time. I made the decision I made, but it was important to hear from her. And I appreciate also that Mr. Jenkins's godparents are on this call, and that they miss their godchild, and he's not coming back. All right. Any last words, Ms. Clark, on behalf of Mr. Russell in connection with the bond motion?
Only, Your Honor, that we're asked that you reduce the bond, or allow them to use a bonding company. 10% bond is very difficult.
Okay. Understood. Mr. Russell, are you able to hear me? Yes. Great. So your lawyer has made a real good argument and helped me understand how life is going to change for you in a way that's going to be a little jarring in a few days. You're going to change locations where you're being housed. I set the bond back in February based on what I learned from your lawyer and your mom, the prosecutor, and family members and supporters of Mr. Jenkins. At that time, I thought that that was the appropriate bond. The only thing that's changed, lots of things have changed, but to me, the one significant thing that has changed is that you will soon be at the adult facility rather than at a YDC. But that's something I was aware of when I set the bond. I felt it was a reasonable number given everything that's involved. And I continue to view it that way. This case has moved faster than I thought. I didn't know if the state would indict or not. That's their call, not mine. I'm now in a position to make sure it continues to move quickly because it got assigned to me. It didn't get assigned to a different judge. So Mr. Abate is under some pretty clear instructions as to how quickly he needs to get your lawyer the discovery, the evidence in this case, and we will keep it moving forward. I'm not going to modify or reduce your bond because I don't think any of the factors that I need to weigh have changed. And I realize that's going to be a disappointment to you and your mother and your extended family. But I still think that that is the number that strikes the right balance between your right to be out and about and the community's right to have a safe and positive environment. So I'm going to deny the motion for now. But Ms. Clark, and I've told you this before, if you are not able to move forward with the case because you don't get the body cam, or I'm making up examples, if the state is the reason why we can't move forward, I'm relying on you to reach out to Ms. Nelson, and we'll have another bond hearing. Because if Mr. Russell is stuck because of something the state is not doing, then he needs to not be stuck at the jail. He needs to be stuck with his family waiting for the state to figure out how to get you whatever you're entitled to. Okay?
Your Honor, can I just ask about the 10% bond? If we could go through a bonding company, perhaps they might be able to make it.
So Ms. Singleton may be able to answer this. I cannot benefit, more importantly, Mr. Russell cannot benefit from Ms. Singleton's services if it is a bond entirely through a bonding company. So that's incorrect. I don't think I can order pretrial supervision. That's what bonding company, they don't do anything like what Ms. Singleton does, but we have bonding companies because they're supposed to make sure a defendant shows up. We do a poor job in this county of forfeiting bonds when someone doesn't show up, but that's not your client's problem. But I have been told repeatedly, not by Ms. Singleton, but by pretrial services, hey, we don't do cash bonds. That's the bonding company. If you want pretrial services, then
Judge, I can't hear you.
I can't hear you, Judge.
Judge, you went out.
We can't hear or see the video.
He's getting it, ma'am.
Thank you.
sorry about that. Ms. Brooks was making some noise and I tried to mute her phone and I muted the entire sound system in the courtroom instead. What's the answer, Ms. Singleton?
So, Your Honor, what happened after the decision was made by higher ups, that the bonds could not be to pretrial. A bond order was fashioned by someone in the court that where it's on the bond order that I'm looking at, it says defendant shall be, it has a shall and shall not.
Yep.
That was added by one of the other courtrooms. And that has been checked to say shall be subject to pretrial supervision. And so the bonds that I have been receiving for the last year and a half have been going through bonding companies with that checked for my supervision.
Well, we'll fix that because I actually redesigned the bond order. And if you look at the bond order, if it's cash or other good bond, it says in it right afterwards, no pretrial supervision, because bonding companies do that and not pretrial services. And that was a byproduct of conversations I had with pretrial services. So it would not be consistent. It'd be internally inconsistent to check one, cash or other good bond, and then shall be subject, because it says right next to cash or other good bond, no pretrial supervision.
All I know is that that's what the courtrooms have been doing.
Okay, we'll work on that. That is a judge error. But my question is, and I think this might work if it were, I'm making the numbers up, but if count one, 50,000 was cash, but counts 2 and 3, 30,000 were through the sheriff's 10% program, I think it would be appropriate and you would be allowed to provide supervision because part of it is through the sheriff's 10% program and not forfeitable to a bonding company. It's not forfeitable in that way. It is money that the family would be putting in that they in fact would get back when the case is resolved. So that was my question, is
Yes,
if
Your
it's
Honor.
split.
That's correct. Yes,
Okay.
it can be a split.
Okay, but this key learning I'm getting from you is that you're saying judges are signing bonds that are AAA bonding and you or a colleague are having to supervise.
Yes.
This job is full of surprises. Okay, Mr. Abate, I'm not interested in changing the dollar amount. I think it is the reasonable amount. And I understood your objections to it back in February, as well as Mr. Jenkins's family's objection. I am more neutral as to how we structure the 80,000. Do you have a perspective on that?
I'll leave it in the discretion of the court.
Okay, then what I will do, Ms. Clark.
There's one extra count, so he,
Oh, does he currently have no bond on one count?
well, since the indictment, he has not been before the court, so there's one extra count that's added that's not, they changed, there's no simple battery, but
Yep.
there is felony murder, which there wasn't on the original one.
Understood. So I need to set a new bond anyway. Currently your client has no bond on certain counts. So I could give him a $1 bond today, or I could modify the old one to $1. He couldn't get out.
Right.
So I'm going to spread the 80,000 across the 4 counts. Count 1, which is the murder, will be $50,000. That will be through a bonding company. So that's however it is met through the bonding company. 2, 3, and 4 will be $10,000 each. Those will all be through the sheriff's 10% program. And Mr. Russell will be subject to pretrial supervision. That supervision will be through DJJ if that's how it plays out, or it will be DJJ because it's an SB 440, or should I say DJJ if he's released before a certain date, and otherwise it'll be pretrial supervision level 3.
Well, it's DJJ just pays for the services, Your Honor, but the supervision is always through me.
So,
but if you could add some type of line that says something to equal the fact that he's moving to the jail, because once he moves to the jail, we would have to come back. If his mother got the money on Tuesday, we'd have to have another bond order that said that removed wraparound services and ankle monitoring by DJJ and added county funded ankle monitor and supervision by myself. So I don't know if it would be easier to just add a sentence that says something about if he's in the Fulton County Jail, he'll receive the county funded ankle monitor.
sure, or we don't have to have a bond hearing if Mr. Russell doesn't post bond until after he's moved. If people just share with me what the right language is, unless Ms. Clark is saying, by golly, I want to be in court for that. I'm not changing the dollar amount. It's going to be that, and it's going to be all these same conditions. You stay far away from Mr. Jenkins's family. You're going to live with Ms. Brooks at that address in Ellenwood, all that kind of stuff. None of that would change. But to Ms. Singleton's point, the wraparound services would be gone, unfortunately. The ankle monitor we pay for by the county instead of DJJ. If we know that realistically, there's not a chance for Mr. Russell to be released before he gets transferred, then we got to just change number 4 on there to reflect that fact. If someone thinks that there is a 1% chance that he'd be released before then we can just modify it if he's not. I don't know the odds of it other than that it's after 2 on Friday.
I would say. I would say that, to modify it so that we have, as if he was at the Fulton County Jail.
Okay, we'll do it that way. So that just in particular for the ankle monitor piece that it says paid for by the county. So I want the Jenkins family members to understand that whatever your view was of the bond that I set in February, dim view, disappointed view, I'm not changing that. So it's the same dollar amount. It's still an $80,000 bond. Only thing I've changed, well, 2 things. They're slightly different counts now. Mr. Russell was in jail on murder and some related offenses. The indictment charges it slightly differently. It's still murder. That's the most serious offense and related offenses. So I had to spread that $80,000 across some slightly different counts. It's still $80,000. The way in which his family can make that bond has just changed a bit. Instead of paying money to the sheriff, they can pay money to a bonding company for part of the bond. All the other restrictive conditions are still there. And this is still if Mr. Russell can make that bond. I did not lower it. So if they can still not do it, that's unfortunate for Mr. Russell, but I continue to believe that $80,000 reflects his alleged role in this process as maybe the initiator, but not the gunman. And that's how we'll work through it. Mr. Abate, any questions about Mr. Russell's situation?
No, Your Honor.
Okay. Ms. Clark, any questions?
No, Your Honor.
I'll get that bond order signed today. And we'll go from Ms. Singleton, anything else we need to do with that?
No, Your Honor.
Okay. I need to figure out that larger bond issue, but that's not this case.
But all the conditions you already had in place remains in place.
All the conditions of the bond from before, no contact with the Jenkins family. You have to live at that address in Ellenwood, meaning your mom's house. Can't be around any weapons, no weapons in the home. Can't leave home unless you're going to school, court, or a doctor's appointment. That's it. As a 24-hour curfew, you're not going to a baseball game. You're not going to Six Flags. You're going to school. And if school's not in session, then it's going to a doctor or to court. Unfortunately, no more wraparound services, but there will be pretrial services supervision, and we do have mental health officers if that would be appropriate in this case. There will be an ankle monitor to enforce that curfew. The quickest way to lose your bond, if you make your bond, is to have that ankle monitor suggest you're not where you're supposed to be. And Ms. Singleton will still be involved with supervision. Oh, and no social media. All right.
And Your Honor, may I give him a copy of his indictment to take back with you?
Do you have it with you?
Yes.
Yeah, as long as the deputies let them take the paper, they may take the staple away, but by all means.
I remember.
Thank you, Your Honor.
All right, thanks, everyone.
Thank you, Your Honor.
We will handle the Roberson plea in a little bit. I got to jump on this Zoom call, and that is it. And I have not forgotten Ms. Hamilton, but you showed up unannounced. So I promise I'll talk with you about it, but I got to take that plea first, okay? Thanks.
Have a good weekend, Joe.
You too. So Ms. Feely, are you allowed off the close supervision by next week, or we'll just let, pardon me?
The chain will be done.
Okay.
Ms. Woods didn't need to come, and I wanted to introduce.
No, it's great. I'm joking. It's good to have Ms. Primovic around. Next week, we have these status conferences for cases that some Ms. Primovic still owns, some she has said, that's a Feely case. So we'll just talk about where those are in relation to being triable since they are on a trial calendar. All right, I'll be back out in a little bit.
Thank you, Ms. Kelson.
Thank you. Have a great weekend. Welcome.
So you've opted under the CP number?
Yeah, you always do. As soon as we get it.
I'll get it to you. We don't know about the gate until the day.
Oh, you don't?
We don't, yeah.
Oh, okay.
But yeah, and if you filed it, if it's in, it'll be in here. So I'll get it to you.
Oh, who's that person?
Our paralegals are trained to look for the SC stuff,
Oh, okay.
but I'll tell them.
No.
Have a good vacation.
Thank you. See you when I get back.
Yes, ma'am.
Just waiting.
Me, this is pretrial, Shirley Gordon from pretrial. Could someone tell me the client that's gonna have the plea and arraignment today? The name of the person?
Name of the person that did it. We already did the plea and arraignment. They already did the plea and arraignment, ma'am. They're just gonna do a waiver.
Is someone having a plea today? If so, I'll need to. Is that Mr.
Donald Robertson.
Oh, Mr. Robinson, not your, Mr. Robinson's having a plea.
All right, is that Mr. Theory?
Yes, it is.
Mr. Theory, this is Gordon. How you doing?
I'm fine by yourself.
So good to see you. I was just wanting to make sure if the judge needed a history that I would have it, but I didn't see this name on my calendar, and I was trying to get the name so I could be ready in case he needed a history.
Okay, I'll, who's this? Let's see.
I don't know which person.
Robertson, I think someone just said.
Yes, Donald Robertson.
I can put it in the chat.
Thank you. That would help me a lot. Appreciate it. Good seeing you, Mr. Theory.
Likewise.
Stacy Thomas. So. Yeah, I don't know. That's when I don't know the calendar. Okay, so she doesn't have counsel as Victoria. So right. Okay, just give me the case. We give me the case. If they withdrew it, they just one more to withdraw.
Or which guy was it again?
The Mounties Pits.
Yeah, please send me the email who served it.
If you fill out the hard copy, I'll fill it out. Just don't really bother.
Okay.
I
Yeah, wait,
forwarded
it's in violation.
the Mounties Pits.
Yeah, I'm gonna be.
Well, they get ready to do a plea.
It's on the fourth floor. I know
It's gonna be probation.
that.
Pretrial is there for the record. I don't know if shit's on the
Can you
record.
still, I mean, you still, all right, is he gonna have probation? You're not,
No,
No,
it's gonna be a pretrial. No, for this plea?
Robinson,
No,
confinement,
yeah.
then no probation won't be needed.
it's, let's see, 4C. All right, you will.
No. There's one over there where the forms are. Or did you want me to? Yeah, because I didn't, it's not printed out. But no, he did not submit one. So you want to know, you say all but his bar numbers, John?
His bar numbers.
Okay. Let's see. I'll look up one of his other cases. So I'll fill that out and I'll put his bar numbers.
Okay.
Thank you. Name is Paul. This is Adam, the pocket from Fulton County Attorney's Office. How are you today? I'm doing okay. Thank you for asking. I just wanted to call. I received the presiding bond calendar for Judge Williams on Tuesday, except from Tuesday. And I just want to make sure you guys were aware, position number 4, Amani Spears. Ronnie Poole has withdrawn the bond motion filed withdrawal. So I just want to make sure you guys can go through the headache of getting her in the booth, and it's already been withdrawn and filed. Yes, position number 4 is. Thank you. Have a great weekend. Thank you. Bye-bye. What's up, man? You okay? Good.
I'm not sure who the previous counsel was listed as an accountant.
Okay.
When you write, it's not that same bad handwriting.
No.
Okay.
Okay, that's told the court. I call the case manager. She won't be. That way, there's no mix up.
Sure, I have. Use the phone call. Right. Use the phone call. It's a body.
What's
that? Use the phone call.
There's no judge of this.
We'll start doing that.
I mean, just today.
Hey, I was looking at this, that's an HP.
Yeah.
I'm ready to get me a new model laptop, look like a little light, and mine seems like one of the old school.
This is a great one. I wouldn't get this one. This one the office provides us.
Oh, how many gigabytes? Is it 4 or 8?
I think it's 8.
Oh, and it's still not that good?
I mean, it's just.
Teacher,
the process
Can you
is
just walk past
but,
them? Thank
I have a Mac that I use. I just don't think that what's called. It's awesome.
So the English not that good, then just because it's saying it's better.
That's what, I don't know a whole lot about computers, I'll tell you that right now.
Yeah.
But it's slow, it moves slow.
I'm ready. I'm ready.
Slow.
I'm ready.
I sound.
No, it's not.
I just know it is nice.
Okay, Microsoft. So you have Microsoft?
Yeah, about a Microsoft Windows computer.
Oh.
I'm trying to
Pretty
be
cool.
strong, love.
It's like a studio.
What's the problem?
And I have a MacBook that I'm a big Mac user.
2142. Is that the
The Apple, like an
yeah,
Apple.
that's the Apple that have the Apple icon on it? Yeah.
I've been using them forever, so, but I bought one. Not everything will play on the MacBook.
Okay.
Sometimes the operating system don't, communicate well. So I bought the Windows or the Microsoft Studio, what's it called. Pretty cool. I like that. But these are pretty cheap. I mean, they get the job done, from what I understand.
Yeah, but getting the job done at optimal use is different.
It's a big difference.
Because it doesn't do any good, especially with these axons and evidence, you have all those gigabytes of information.
I've now started putting everything on like an external hard drive, so it doesn't slow it down. Because that's what makes this stuff so slow. It's a pain, but it's a good way, I guess, to back up.
Yeah.
When
your first grade started. 27, it was small. It was a little bit. It was a lot. You talking about? That's kind of right. I'm gonna do that. I'm gonna Is the waiver? I know. He got me. He got me. I can't do it. No, yeah. Actually, we just thought about it. Thought about it, and it's just talking. Yeah, okay, so we go for it.
Like when he was still chief.
I
Okay.
San Diego.
Today, and I'm like, thinking, okay, low hanging fruit, low hanging fruit. All you get is, low hanging fruit.
Man, he's still back.
And then I'll be going to the jail, like I wound up going to jail 6 months on the weekend, for the most part. And so, you know, all the cases, I have quite a few to see. I can't just come back and somebody, oh, I think it's 20 years. But the court uses it's now, triple case you, triple defending case, all loose or something. Yeah, they all play guilty. The barbershop. The barbershop. Yeah, the garage. Two of them got 20 and one got 30. Speak for murder. But this is 22 years old.
You want to hear? No, we know that, right?
And then 30 years of being a road on that was kind of I've been having the civil stuff going on and successful stuff. So I come back here and back when we move to all these serious cases. Why don't we take a check? Stuff that and keep doing it. Just change.
Two one to 49.
Yeah,
59. That's right.
Everything I can try to do that. Basically, There's Monday. That's a long time.
I have to get the future records. One is okay. Because I recently bring it up next week. Okay, so we signed, so if he signs that, or what do you say? I'm wondering, we need to bring it, how do we get the board? Just.
Order. Yeah.
Because this, so will your order? The doctor is the merger, yeah, because that's just gonna put the case on hold, it's not gonna lift them.
I would send you a motion for order, proposed order lifting. I'll see that.
Okay, yeah, so if he gets that, and then he signs it to version, the next. Okay.
She called you Miss Drew. I'm like, Miss Drew. I was looking around. That's what
Oh, she's getting me a door.
Not by the rest. So, what's gonna happen?
I think the order. I'm going to.
Yeah. They want to talk about that 4 years
So, yeah, that's.
At 27.
What?
27.
That's fine.
All the motions.
I tell you what, yes. You want 3 days or 2?
You're not gonna take That's a lot. I know you. I said that. Yes, and I did, I said that. I went for the judge side as well. I told them myself.
Thank you.
Okay, will you send that to Ms. Charles, because he just signed the version.
Sure.
Thank you.
So you're gonna be careful.
Yeah.
Yes, I have it all. This is the factual basis.
You know.
So we just pleaded to count 7 and jump to, this is 10 years to serve, this is 5 years to serve consecutive suspended. It's 7, 8, 9 don't apply to him. Count 10, that's 10 years to serve. And then that's 9. That's 9. 1 to 10.
Be terrible, Brian, be terrible. Go ahead, do your thing. Take it easy. You do everything you gotta do. Mine Dolphins fan? Yeah, man. And we're going to start off.
I think I should have done it.
How you like, I'm gonna didn't do that much. I mean, basically, they're being in the shower, you have hell. I mean, we lucky to be close around the middle of the pack. Might be second in the NFC South in Tampa Bay. Yeah, definitely 5 minutes last. Other than that, I mean, just low expectations. Yeah, but that. I don't think, I mean, what's that? I mean, they got a high, what, their third round kids, you know. Yeah, that's not going to. We got third round, third round. Well, he says the guy, at least in some kind of development, you know, they can, you can develop and possibly be a feature star. Mariota. I'm interested, y'all got a whole bunch of friends. Let's see what y'all defense does.
No, that was that one day that we waited all the way.
That's AFC South, right?
Yeah.
AFC West is South.
That's great.
Jacksonville. No. Miami,
See it, the officer just talking.
Miami did it right. Oh, Buffalo.
Look at you utilizing it.
San Diego. No, Kansas.
I was forgetting that they were losing around.
Cincinnati.
It was with our, you know, the number of they're all together.
Jets.
Why would we pay attention to what you're saying? You can't really expect much, you didn't expect much from last year. I think before we were hurt, we saw like 140 yards a game. Yeah. At least it wasn't throwing all the interceptions. But now they got that wide receiver that we are receiving. They got it. So now they might start having a passing game. Yeah. The defense only so long that they're gonna be able to start keeping those players, especially if they're not having a salary cap. Offensive line, they've been started going down and let everyone out there. And then the other, at Ramsey, I got that from North Idaho was one. Yeah. Because, but I was more happy that it got, we did a reach for a quarterback in the first and second round. Might be.
He comes back, how you feeling? Doing okay? He's doing all right? James.
I don't know. We'll see, man. He hasn't been freshman last year. Yeah, but he was throwing like 140 yards a game and stuff like that. 140, 150 yards a game, that is.
You know, we got a good defense, we're watching them on the field, decent quarterback. He's a defense in the game. Remember the year when they won the first Super Bowl?
Yeah, I know, Chip Guilford.
Yeah,
But Chip Guilford, right? Yeah, that was like Jamal Lewis too, or something, right? Yeah, well, was that with Shannon, was on the Shannon show?
I think so. That's why.
Yeah, Tony Saragusa and stuff.
Yeah. And Slug. Slug and Slug. Terrence Slug, Terrence.
Oh, yeah, Terrell Slug? Yeah, that was like Tony Saragusa, after that.
Yeah.
They got someone big dude before.
And Reed.
Serious squad. Yeah, see, that was a real serious squad.
Yeah.
But you know, that's a defense. You gotta have a defense like that. Now our defense been better over the past few years. Having it like that. You know, that was some Hall of Famers on that team.
I know. That about 4 or 5. Like Ray Reeves, Ray Lewis, Sam Sharp, who else?
Ogden, Jonathan Ogden, at offensive tackle.
Oh, yeah, Ogden, yeah. Damn. That's 4 right there. That was squad too. Bye, Deidre.
Bye, love.
I'll be back. Call me on the evening. All right, there.
Take care.
He knows. He knows. Hopefully he comes out and arrested.
Mr. Abate, I feel like you may get jammed up at 3, or you had somewhere to be at 3. I thought I'd be able to leave at 2, but the Russell conversation took a little bit longer.
I think I'll be all
All right, if you need us to call someone to say you're here, let me know and Ms. Nelson can reach out. Okay, all right. Are we ready for Mr. Roberson?
Yes, Your Honor.
Anything we should talk about in advance?
We have a negotiated plea.
Okay, I wasn't, like, I expected something. I just wanted, it was anything I needed to know. Is it similar to Ms. Marable's plea?
It's almost identical.
Okay, and you've worked with Mr. Roberson. He knows what to be expected. Assuming I go along with it, he knows what to be expecting.
Yes, Your Honor.
Fantastic. Thank you for working with him. Let's bring Mr. Roberson out when you are ready, sir. And Ms. Charles, are you still here because of Ms. Hamilton? Okay. Great. As soon as we finish the Roberson plea, we can talk. I'll probably need some proposed language. I won't type it up right now. I'm happy to do another letter. I'll just need some language so that the second letter does what Ms. Hamilton needs it to do. Hopefully does.
It is okay with the court when I finish, I guess, my recitation of the factual basis of the plea. If it's after 3, I may let Ms. Charles finish. Please inform me if that's okay with the court.
If it's okay with Ms. Charles. Yeah, no, I appreciate you staying as long as you can, and you're welcome to streamline the facts. Mr. Roberson needs to be comfortable that you know the evidence, but I've heard the sort of transferred intent. Mr. Roberson, Ms. Marable, and the deceased were, from the state's view, the aggressors. Someone fired back after the deceased unloaded a bunch of poorly aimed rounds. Hit. Ms. Rivers, are you ready?
Yes, I'm ready.
Great. Mr. Roberson, how are you? You ready to go forward? Okay, the microphone is on. Good. All right, you're gonna need to speak up, Mr. Roberson, so the court reporter who is appearing remotely can hear you. We are gonna go forward now on indictment 22 SC 182150. That's a reindictment of a case that is on our current trial calendar. Earlier this week or late last week, we took the plea with co-defendant Marable. We have today Mr. Roberson, AKA Pokey, who is charged in counts 1 through 7 and count 10 in this new indictment, the 22 SC case. Mr. Abate and Ms. Charles are here for the state. I'll probably be hearing from both of them. And Mr. Theory represents Mr. Roberson. Mr. Roberson, if you are ready to go forward, Mr. Abate is going to put you under oath so he can ask you some questions about your rights as a criminal defendant. It's important that you answer all of his questions and mine truthfully and completely. It's also important that you let me or Mr. Theory know if you've got questions of your own, if you can't hear what's going on, or all of a sudden someone's talking about armed robbery and this case isn't about armed robbery and you're confused, call timeout and make sure Mr. Theory or I get you to where you need to be, okay?
Okay.
Excellent. Mr. Abate.
Thank you, Judge. You'll please raise your right hand, sir. Do you solemnly swear or affirm that the testimony you're about to give in the matters pending before this court will be the truth, the whole truth, and nothing but the truth, sir?
Yes.
Okay, you can put your hand down and just make sure you speak real loud into the microphone so Ms. Rivers can hear you, okay? Could you please state your true, correct, and legal name for the record?
Donald Cornelius Robinson.
Okay, and Mr. Roberson, are you taking or under the influence of any alcohol, drugs, or medicine at this time?
No.
You got to sound loud.
No.
And is there any medication that you take on a regular or daily basis that you have not taken today that would affect your ability to understand why you're here?
No.
Okay. And are you able to hear him, Ms. Rivers?
Yes, I am.
And how old are you, sir? And how far have you gone in school?
49.
And how far did you go in school?
10th grade.
Okay. And are you able to read, write, and understand the English language?
Yes.
And do you understand that you're charged with the following offenses in indictment number 22 SC 182150? Counts 1, 2, and 3, all felony murder. Count 4 and 5, both aggravated assault with a deadly weapon. Count 6, criminal damage to property in the first degree. Count 7, possession of a firearm during the commission of a felony. And count 10, possession of a firearm by a convicted felon.
Yes.
And do you understand that counts 1 through 7 will be dismissed and you'll just be pleading guilty to count 10, the possession of a firearm by a convicted felon?
Yes.
And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial.
Yes.
And has your attorney, Mr. Theory, gone over the waiver of rights form or the rights that you're waiving by taking a guilty plea here today?
Yes, it have.
And have you had enough time to speak with your attorney, Mr. Theory?
Yes.
And are you satisfied with his services?
Yes.
And Mr. Theory, do you waive formal reading of the indictment?
So waived.
As well as any and all defects in the indictment, including any with respect to your client's name for the purposes of this plea?
So waived.
And Mr. Roberson, has your attorney advised you of the minimum and maximum sentence for the count 10, the single charge that you're pleading guilty to?
Yes.
And did he advise you for possession of a firearm by a convicted felon, the minimum was 1 year, the maximum is 10 years?
Yes.
And sir, do you understand that this is a negotiated plea of guilty, which means the state and your counsel will make a joint recommendation to the court, but the court does not have to follow that sentence and can sentence you as he sees fit?
Yes.
Okay. Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes.
And do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation regardless of any advice given to you by your attorney or anyone else, sir?
Yes.
Do you understand that you are waiving any and all defenses by entering a plea of guilty here today?
Yes.
Do you also understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury,
Yes.
the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you were unable to afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. Do you understand that you are waiving or giving up all of these rights by pleading guilty here today?
Yes.
And I may have left out, and I apologize, the right to testify on your own behalf and to present other evidence. Do you also understand that you're waiving or giving up that right as well by pleading guilty here today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter this guilty plea here today?
No.
And is it your decision to waive these rights and enter a guilty plea because you're in fact guilty, sir?
Yes, sir.
And how do you plead to count 10, possession of a firearm by convicted felon in indictment number 22 SC 182150?
Yes.
And is this guilty plea freely and voluntarily given with full knowledge of the charge against you that you're pleading guilty to?
Yes, sir.
And do you understand that you may have only a limited right to appeal this guilty plea conviction?
Yes.
And do you understand that you have only 4 years from today to file what's called a habeas corpus petition challenging this guilty plea?
Yes.
And as your attorney, Mr. Theory, explained to you the process that's involved with a habeas corpus petition?
Yes.
Okay. Your Honor, had this case proceeded to trial, the state would have proved beyond a reasonable doubt that on December 24th, Christmas Eve, 2018, at 1190 Oakland Lane here in Fulton County, Atlanta, Georgia. It's the Oakland City West End Apartments. During that late afternoon, early evening, the defendant, Mr. Roberson, and some other individuals were playing a dice game at the Oakland City West End Apartments. During that dice game, Mr. Corey Miles, who was also involved in the game, had, according to the defendant, lost $5 and owed the defendant, Mr. Roberson, $5. Mr. Miles disagreed. They got into a verbal argument, and at that point in the evening, Mr. Roberson then left Oakland City Apartments and then proceeded to his cousin's house right down the street, his co-defendant, Ms. Tarika Marable. At that point, when he arrived, they then called Ms. Marable's significant other, Mr. Bartholomew Smith, and asked him to come over because he was, according to the accounts or the statement given by Ms. Marable, a better fighter than Mr. Roberson.
This is the guy whose name was Sin?
Yes. Sacrifice is, if necessary, I believe was what Sin was short for.
Okay.
And at that point, Mr. Sin did come over to Ms. Marable's apartment. They all got into Mr. Roberson's black SUV and drove back to the Oakland City West End Apartments. When they arrived there, Ms. Marable was driving. She parked the vehicle directly behind the blue Charger that was owned by Mr. Miles. The blue Charger was also occupied not only by Mr. Miles, but his friend, Mr. Devon, which is D''VON cousin. At that point, Mr. Roberson and Sin, Mr. Smith, got out of the vehicle and began to yell at Mr. Miles and Mr. Cousin. Mr. Smith, or Sin, when he got out of the car, was armed with a handgun and was wearing a ski mask, and very shortly after began to fire into the car. Luckily, Mr. Miles and Mr. Cousin were able to escape the vehicle. Mr. Miles was armed with a handgun as well and fired back at Mr. Smith, shooting him in the chest. And he subsequently died due to that gunshot wound. Mr. Miles and Mr. Cousin were able to escape gunfire. And at that point, APD, or the Atlanta Police Department, got involved and the investigation began. And they were able to determine that Mr. Roberson and Ms. Marable were involved in the ultimate death of Mr. Smith. Based upon that, Your Honor, that's what the state would have been able to prove beyond a reasonable doubt if this case proceeded to trial. Mr. Roberson does have 2 prior felonies. He does have a murder case that was reduced back in 1992 to a voluntary manslaughter, and that is indictment number Z39984, where he was sentenced to 20 years to serve 10 years on the lesser included voluntary manslaughter. And then back on February 28th of 2012, at the Gwinnett County Superior Court, he pled guilty to forgery in the 2nd degree, where he received a probation sentence. Those are the only 2 convictions that Mr. Roberson does have on his criminal history. Typically, I'll represent to the court with Mr. Roberson's history. this is not something the state typically would go forward with, because he does have a prior murder that was reduced. But based upon all the facts and circumstances and the totality of the facts as it pertains to this case, the state believes that this is the best and most just and fair outcome, despite the history of Mr. Roberson as it pertains to his involvement in all the facts and circumstances. The state has no objection to Your Honor signing for the state on the indictment due to COVID, and I believe the defense has no objection as well after speaking with Mr. Theory. Nothing further from the state.
It's a plea to count 10.
Yes.
The state's null processing 1 through 7.
Yes.
And it's a recommendation of 10 years to serve.
Yes, Your Honor.
All right. Ms. Tucson, good afternoon. Thanks for joining us.
Good afternoon, Judge.
Do you have any other information about Mr. Roberson?
That is the same information that I have here in the system on his priors.
The
Fulton for the voluntary manslaughter in 92, Z39984.
Right. My question, the Gwinnett case, that's closed out?
And then the Gwinnett case is closed out, yes.
Okay, great. And Ms. Gordon, good afternoon. Thank you for joining us. Does pretrial have anything more in terms of cycles or anything?
We are showing 12 cycles beginning in 1990s, a multi-state offender with the rest from the states of South Carolina and Georgia. We do show the prior felony convictions, 92 of voluntary manslaughter and second-degree forgery in 2012 from Gwinnett County. Nothing further to add, Your Honor.
No convictions out of South Carolina, just some arrests.
That is correct, Your Honor. 1 arrest.
Okay, thank you so much. Appreciate it. Mr. Theory.
Your Honor, as you heard, Mr. Roberson is 49 years old. He finished the 10th grade, but attained his GED. He has 3 children and 6 grandchildren. His sister is present, and we'd ask the court to accept this negotiated plea. Mr. Roberson is aware of the circumstances and sorry for the circumstances that wound up causing the death of Mr. Bartholomew Smith. We'd ask the court to accept this negotiated plea for 10 years to serve regarding this possession of a firearm by a convicted felon charge.
Okay, and that's certainly the charge that we're working through. Of course, the 10 years are driven more by the fact that, once again, Mr. Roberson was involved in a situation where someone died. I don't think anyone is under the illusion that the crime of possession of a firearm by a felon, that's 10 years. But to your point, Mr. Theory, it's the other circumstances around it that I think make that a reasonable negotiated resolution. Mr. Roberson, your children are old enough to have kids. How young is your youngest child?
My youngest is 29.
How old is your oldest?
31.
Okay, so they're tightly packed. Your older case, the killing back in 92, you had a co-defendant in that. What were just the basic circumstances of that case?
Well, it was a situation where we was all out, and my co-defendant got in. I was with a guy, and pretty much the same. He ended up shooting someone, and they charged everybody with the murder.
Yeah, the other name isn't coming up, but so that's the Maurice Reynolds. So Maurice Reynolds gets into it. You're part of that situation, sort of like part of this situation. Someone ends up dead, party to a crime. You're in the mix.
Right.
All right. You got to hang out with different crowds, I guess. All right. I appreciate you sharing that. You have anything you want to add about this case, about your situation?
No, sir.
Okay. Well, Mr. Roberson, I find that there's a factual basis for your plea. Just so you know, I heard a bunch more about this case in Ms. Marable's plea. I have more questions. I was trying to figure out, well, wait a minute, like the person who got killed was actually the supposed aggressor. There's a discussion about whether you had a gun or not. And one witness apparently would testify that he or she saw you with a gun as well, not shooting, but you had a gun in your hand. So I know a little bit. I say I know. I've heard a little bit more about the circumstances. Ms. Marable gave me her perspective on it about maybe Mr. Miles wasn't a great guy. That's not the point of this. Mr. Miles isn't the one who ended up laying on the pavement with a bullet in his chest. But I do think that if this went to trial, a jury could conclude from all the testimony that you were part of the group that started the situation that resulted in Mr. Smith's death. Not that you killed Mr. Smith, not that Ms. Marable killed Mr. Smith. No one's saying that. But the law works in a sort of unexpected way. If you've experienced it apparently twice, you know what the deal is because of the situation with Mr. Reynolds. You may not have done anything. Someone's dead. You're part of the mix. You have some criminal exposure, not just some, but a lot. Given your history, the state could easily have asked for life without parole in this case for you. You die in prison. You're not young, but you've got an end to your sentence. The most time you'll serve, absolute maximum you'll serve is 10 years. You've already served a big chunk of it. You'll get credit for that. You may get paroled. So you at least have a known quantity as opposed to if this went to trial and it didn't go well for you. I also find that your plea is knowing and voluntary. Voluntary means what it says, that you're entering this plea of your own free will. You've got good advice from your lawyer. You've had a chance to think about it, and you've decided that this may not be a great thing, but it's your best option. Do you agree with that?
Yes, sir.
And a knowing plea just means you've understood all the things Mr. Abate and I have talked to you about, and you don't have any questions. Is that also true?
Yes.
I'll accept your plea. We'll be dismissing counts 1 through 7. I will sentence you to 10 years to serve on count 10, and you will get credit for all the time you've been in custody. That's baked into the sentence, actually written in the sentence, credit from the day of your arrest. I know you've been in for a while. I have been pushing on your lawyers, and you've gone through 3, no fault of your own. We finally landed on one who was getting some traction. So thank you, Mr. Theory. Thank you, Mr. Abate, for focusing on this case. And I think that, signing the indictment. Mr. Roberson, I'm going to sign the indictment electronically for you. If you give me the green light to do that, Mr. Abate has already said I can sign for him. We used to pass indictments around. We tried to pass around less paper during the pandemic. May I sign for you?
Yes.
And Mr. Theory, may I sign for you?
Yes, Your Honor.
Excellent. I will do that. And I think we've covered things. Mr. Abate, anything else for the state?
No, Your Honor.
Mr. Theory, anything else for Mr. Roberson?
No, Your Honor.
We're done. Thank you, everyone.
Thank you.
Oh, I think you've no prossed the old indictment.
I believe we have, but if we haven't,
You're doing it again?
yes, Your Honor.
Okay, we may have made it only go away as to Marable. We'll make it go away as to Roberson as well.
Perfect.
Great, thank you.
We can technically say we closed 2 cases.
If only it worked that way.
Y'all have a nice weekend.
You too.
Thank you.
Mr. Theory, we have some status conferences next week. Well, I think we call them pretrial conferences for the upcoming trial calendar. And some of the cases are yours, and some of them you've already told me, look, I can't be ready. Or, hey, Judge X has me specially set. I still want you to show up because I want us to be able to have a conversation about, well, let's pick a case. Ideally, Mr. Abate will be in the room where I can specially set it so I protect you, or from my view, I grab you, I get you. But it's a case that you're comfortable between now and whatever date that's going to be, you can be ready on. It won't be the June 2 date. That's not my expectation, because I think you're specially set, if not for that date, in sort of a sandwich around it, Judge Cox, Judge Adams, et cetera. I share all this just because I don't want you to skip our pretrial conferences. I want you to be here so that we can talk logistics going forward for those cases that you're not able to work out, like Mr. Roberson's.
Yes, sir, Your Honor.
All right.
And I'm not in the habit of skipping, calendars with my names on them, Your Honor.
I didn't think so. That wasn't my point, and I've not had that experience with you. But I've also told you, oh, I hear you that you're stuck in these other courtrooms. I didn't want you to think, oh, well, he must have mistakenly. It was not a mistake. I wasn't trying to waste your time. Okay.
Never think my name being in your calendars is a waste of time, Your Honor. And I will be here that day, and I will start looking over to see which one of those cases could be specially set for a trial.
Great. Sounds like a plan.
Thank you, sir.
You're welcome. All right, Ms. Hamilton, why don't you come on up to the table there with Ms. Charles, and we can talk a little bit. Oh, you're there. That was fast. So I have lots of cases. I want to make sure I'm remembering yours. The defendant in your case was your mom.
Correct.
She used your identity. She got benefits. She messed up your credit. I'm not dumping on your mom, but I'm remembering the right case.
Correct.
This is your mom actually like literally fell out in court once.
Yes.
You may not have been there for that one, but there was a time when we had to get some paramedics in here. All right. I'm remembering this. You were in the military?
Yes.
Okay. Are you still in the military?
No, Your Honor.
Because of what your mother did, your credit's messed up, all sorts of things. You wanted to get a new social security number so that that's sort of free and clear of all the things stuck to your old social security number. But then there was more. You're trying to change your name?
Yes. That's
Okay.
correct. When I went to the Social Security office with the letter there, one, they said they weren't going to accept that because it wasn't, legitimized as far as like a notary, as well as they did recommend to strengthen my chances to be able to get a new social security number that it's recommended that I can get a name change as well.
Do you have to go like all the way to Jane Doe, or you just change a couple letters, or what?
Well, they recommended my last name to be changed. I don't necessarily have to do my first and last. So.
Okay. Do you live in Fulton County?
No, Your Honor. I live in Gwinnett County.
Okay. I think that has to happen in Gwinnett County. You may want to ask around the name change part, because we do handle name changes. But I think we handle them for residents. In other words, if you were from Gwinnett or just from Texas, you couldn't come to Fulton County to change your name. You get your name changed in your county of residence. I'm not 100% sure on that, but I think that's how it works. I'm happy to help with it. I just wouldn't want it to be ineffective because you're getting it in a court that's not the superior court where you live. So I don't know if you've researched name change.
They just recommended that, from the judge, they didn't really specify which judge, but being that, you were the judge, a part of my case in particular.
Right. And of course, I'm happy to help, but to be clear, I'm really the judge of your mom's case. My legal connection to you is that you're a victim in a case where I had the defendant. I couldn't, if I was mad at you, I couldn't do anything to you. I'm happy to help, but it's that one step removed thing. So we should try to do what is necessary. And it makes sense. I think of all the judges on the planet, I'm the one that makes the most sense because I can articulate that you were a victim of the identity fraud, which is why you need the new social security number and potentially even the new name. Let me look something up.